नमस्कार, राज्यसभा टीवी के खास कार्यक्रम संसदीय वाद विवाद में आपका स्वागत है। मैं हूं अरविंद कुमार सिंह। इस एपिसोड में हम चर्चा करने जा रहे हैं संविधान संशोधन विधेयक 2012 पर। पिछले एपिसोड में आपने देखा कि इस पर चर्चा के दौरान सांसदों ने किस तरह से उच्चतम न्यायपालिका की गरिमा के हक में बहुत सारी महत्वपूर्ण बातों को कहा और साथ ही साथ कई महत्वपूर्ण सुझाव भी दिए। इस एपिसोड में हम आपको दिखाएंगे कि सांसदों ने और क्या कुछ कहा और मंत्री ने जवाब क्या दिया।
सरदार सुखदेव सिंह जी।
थैंक यू सर। ये बिल किसी जुडिशरी के लिए कोई खिलाफ नहीं है, बल्कि मैं समझता हूँ ये जो सुप्रीम कोर्ट के जजेस हैं, रिटायर होते हैं, उनकी इज्जत बचाने के लिए है या जुडिशरी की इज्जत बचाने के लिए है। और इन्होंने एक सुझाव भी दिया जो मैं भी सपोर्ट करता हूँ कि उनकी एज बढ़ाई जाए कि जजेस का बहुत बड़ा रुतबा होता है, खास करके सुप्रीम कोर्ट उसके ऊपर तक होता नहीं। खन्ना साहब ने बिल्कुल ठीक कहा कि वो किसी को फांसी से बचा सकते हैं, किसी को फांसी दे सकते हैं। तो जो खन्ना साहब ने कहा कि ओपिनियन को ऐसा दे दे जो उसके अंडर काम किया हो या उन्होंने जज बनाया हो, तो कुदरती है उस जज पर, फैसले पर उसका असर होगा ही होगा। तो इसके लिए मैं समझता हूँ अमेरिका में जज रिटायर ही नहीं होते, वो सारी जितनी देर उनकी डेथ नहीं वो रिटायर नहीं होते। कोई ऐसा प्रोविज़न डाल दें कि वो रिटायरमेंट तक चलें या 5 साल उसकी एक्सटेंशन हो जाए या कॉन्ट्रैक्ट बेसिस पे जजेस को रख दिया जाए। एक मैं लॉ मिनिस्टर साहब से ये रिक्वेस्ट करूँगा कि कुछ ऐसी पोजीशंस में लोग बैठे होते हैं, कॉन्स्टिट्यूशनल पोस्ट होती हैं, जैसे चीफ इलेक्शन कमिश्नर है, इलेक्शन कमिश्नर है, और या CPI का डायरेक्टर है। तो जो कुछ ऐसी पोस्टें हैं जो उसके रिटायरमेंट के बाद उनको कोई भी ऐसी जगह नहीं मिलनी चाहिए ताकि लोगों को इंसाफ मिल सके। जुडिशरी की इज्जत बचाने के लिए, सुप्रीम कोर्ट के जजेस का स्टेचर बढ़ाने के लिए ये अमेंडमेंट है, मैं इसकी सपोर्ट करता हूँ। थैंक यू सर।
श्री वैष्णव परिदा।
I rise to support this amendment. Sir, in your constitution, this 124, this clause, this article has said that the judges of the Supreme Court, they are forbidden to take any assignment in any court of this country or to participate in any arbitration inside India, and nowadays also not in abroad also. But it's found in many cases some of the judges could not uphold this principle of our constitution. They indulged in some works, in some arbitration work after the retirement, which hampers the prestige and dignity of this judiciary. So the Parliament has the duty also to maintain the dignity of judiciary also, its independence also, and make some rules to strengthen the judiciary, to strengthen its independence and strengthen its dignity also. It will help to strengthen the democratic system of our country. Thank you, sir.
Now, Dr. M Sudarsana Natchiappan.
Chairman, sir, this bill is very important bill, and also our Honorable Law Minister, he has got a chance now in the history to bring some sort of regulations in the judicial system. Judiciary is now the highest accepted institution in India to give a clear verdict on any controversial issue. If there is a dispute between a state and one state to another state, or state to the union, then that dispute can be solved by the Supreme Court of India. This was not happened in United States of America. United States of America is having a Supreme Court for every state. They have got every federal district courts also, they are having it. Therefore, two type of system, judicial system is available in the United States, but we are having single system of judiciary. Only in India, even the law made by the Parliament or the Assembly can be set aside by the Supreme Court of India in the way of reviews powers. But nowhere in, even UK, you cannot set aside the bill. They can recommend that this has to be considered. In the United States, they can comment upon it. Therefore, such a supreme power is given to the Supreme Court judges. Therefore, they should come forward with certain things which could not be done by others. Therefore, this restriction in this particular article is given that they should not go for any practice or any such thing like that. But unfortunately, we have to look at the issue of the human rights aspect also. A judge who is only 65 years old. Now many of the peoples are becoming wise only after 65. When the 65 years old person who was having a period of 5 years, average period of Supreme Court judge is only around 3 years. Therefore, when he is having 5-year period and he is retired in 65, his wisemanship and also the practice in the law and the way of learning in the system, it should not go waste.
Why not extending the retiring age of Supreme Court?
Yes, sir. That is why I want to submit that one also, because we have borrowed the system of United States and also the United Kingdom. In both the places, the judiciary is not having any age of retirement. They can voluntarily withdraw themselves, but they are entitled to all the perquisites which were given to the sitting judge. If that is the position taken by India, then we have to see that the judges need not be doing for other businesses. But at the same time, now the universal globalization has come up, many of the knowledge has come up. They can go for lecturing, they can go for any other training programs and other things. In that way, this is a way the judiciary's people who are well trained have to be accommodated. Now, many of the people are vying to become, even relinquish the Chief Justice of a particular state High Court. They are coming to the Supreme Court simply because the statutory positions are available for them. We have created many of the Human Rights Commission, many of the tribunals, many of the regulatory authorities, even Competition Commission was pending before the Supreme Court till we accepted that the judiciary can be the part of it. Then when the executive has accepted it, then they made it passed. This is the way the judiciary is asking for some demand to place themselves. Therefore, the question is whether they should be prohibited from going for any other practice by using that knowledge for the society, or they should be restricted only to the government nominations, or they should be asked to go for lecturing and get this salary from the exchequer of the government. This is the question has to be answered. That question the government can consider about it, so that the judicial system should be independent. They should not do something which will create a color in their life to say that they have taken a decision in that particular judgment because they sought for a governorship, they sought for a Rajya Sabha membership, they sought for a particular position in Human Rights Commission or in the tribunal or any such position. They should be the autonomous body as the constitution makers make it. Thank you very much.
Thank you, Mr. Natchiappan. Sri A.V. Swamy.
Thank you. I have 3 points only to submit, sir. Number 1, society and most of us as social workers also have lost faith in the various organs of the government, including legislature, executive, and also the other institutions which have been created. The only hope lies in judiciary for most of the people. I congratulate Duaji for having brought in this particular amendment to the Constitution, which if it is not done, will reduce the prestige of the judiciary further in the minds of the common man, because they are resorting to chamber practice. That means he is becoming another wage earner and not a person who dispenses justice. Third, sir, I am not in favor of increasing the age limit of judiciary. For the simple reason, age has its own impact on the reflex action of any person. I am 84. I have started feeling it, even though I try my best to be what I am at 25, but it is difficult. I think if you want to be kind to good judges, let them be given a better benefits at the time of their retirement, not increase their age limit. Sir, finally, I would thank Mr. Dua to have made one point very, very clear. He was concerned not so much about the systems and all that, in a depleting values that we are facing in the society. Some people to whom common man can look at and say, here is somewhere I can trust, that is only judiciary. And therefore, I fully agree with the constitutional amendment. Thank you very much for giving this.
Thank you.
इस चर्चा में शामिल सांसदों ने कई महत्वपूर्ण तथ्य सामने रखे। उन्होंने दुनिया के तमाम देशों की उच्चतम न्यायपालिका की स्थितियों को भी सामने रखा और कहा कि भारत में अगर इनकी वकालत और सलाह देने पर पूरी तरह प्रतिबंध लगाया जाता है तो इसकी भरपाई के लिए भी सरकार को इंतजाम करना चाहिए। फिलहाल हम लेते हैं एक छोटा सा ब्रेक और इसके बाद आपको दिखाएंगे वाद विवाद।
If we have to reduce the load of the pending cases, Honorable Vice Chairman Sir, then we need to have alternative forum. And we need people judicially trained for that alternative adjudication. Arbitration is a part of that. Therefore, sir, if you have a complete blanket ban that no retired judge ever can undertake any arbitration, that maybe wittingly or unwittingly you are impinging upon the success of alternative judicial redressal mechanisms.
ब्रेक के बाद आपका स्वागत है। आप देख रहे हैं हमारा खास कार्यक्रम संसदीय वाद विवाद और मैं हूं अरविंद कुमार सिंह। हम चर्चा कर रहे हैं संविधान संशोधन विधेयक 2012 पर, जो कि गैर सरकारी सदस्यों का विधेयक है। इस पर चर्चा के दौरान तमाम सांसदों ने बहुत सारे पक्षों पर सहमत जताई, साथ ही साथ कई उपयोगी सुझाव भी दिए। आइए आगे आपको दिखाते हैं कि सांसदों ने और क्या कुछ कहा और मंत्री ने क्या जवाब दिया।
Dr. Keshav Rao.
Sir, the question is about a man who is holding the highest position after his experience, when the nation has accepted his expertise and he has brought into a big position. Now, should he take up the other position, which is little, I would not say lower, but which perhaps compromises his own stance? What happens is, in arbitration, he may run the risk of giving a arbitration award which may go against one of the awards of his own. It is not about money, it is about the prestige and the dignity of the office that we hold, and let us not compromise it. But one thing is, at 65, Natchiappan feels, a man may feel young, at 70 he would also feel young. Let us not bother as long as he is in the office. So this is for the government to do. I stand to commend the resolution, the bill, sir.
D. Raja.
Sir, I rise to support the bill moved by our beloved colleague, Mr. Dua. The constitution is very clear, 124/7. No person who has held office as judge of the Supreme Court shall plead or act in any court or before any authority within the territory of India. Now, what our friend Dua wants to do, after within the territory of India, add outside India also. That is the simple amendment he moves. And what our friend Sudarsana Natchiappan said, whether you can increase the age limit of judges or whether you can increase the effects or benefits to judges, there I think the second amendment, provided he may do so upon a request made by the President or the Prime Minister of India or the Governor or the Chief Minister of a state in a matter of national interest. There he clarifies that thing. And I urge upon the government, you consider bringing back the National Judicial Commission Bill and Judicial Accountability Bill, because the time has come.
Now, Honorable Law Minister.
Honorable Chairman, sir, Deputy Chairman, sir, I am indeed very grateful that Honorable Member, our esteemed senior colleague Mr. Dua, provoked such a lively debate by his private member resolution. Sir, before I come to the matter, I see the point of what Duaji has made, sir. Honorable judges of High Court or Supreme Court today, Supreme Court judges after demitting office cannot practice anywhere in the country. High Court judges after retirement cannot practice in any High Court, in their own High Court or subordinate tribunals in their jurisdiction. What Duaji has sought to highlight is they must stop undertaking arbitration and they must stop giving legal advice. About the legal advice part, I totally agree with the sense of the House. Speaking for myself, Honorable Vice Chairman, when I used to appear in Supreme Court or when a client I used to come with me, okay, this is the opinion of the Chief Justice of India, I used to say gently, we will decide it separately. There is no need to enclose it. Please don't do it. And it will only be appropriate in the fitness of thing, taking into account the kind of concern expressed by Duaji that retired honorable judges and retired honorable chief justices, even if they give their opinion, they must say it very clearly and categorically, it should not be used for any pending legal proceeding. But sir, as far as the legal advice part is concerned, that has already caused deep distress in the judiciary itself. And sir, Supreme Court, in the case of Grenadiers Association, Rohtak chapter of the Union of India, has itself come with a direction that if any case filed, if any opinion of any retired chief justice is enclosed or a retired judge is enclosed, then the registry must see to it that is removed. It is a very salutary judgment given by the Honorable Supreme Court of India. And based upon that, sir, Delhi High Court in a common cause versus Union of India has also held the same way, that henceforward any written opinion of any retired judges or chief justice shall not be made a part of any pending case, pending or to be filed for any purposes. So that concern of Duaji has been taken care of, sir. As far as the second plea of arbitration is concerned, sir, I would like to say that the government, previous government, has already brought a bill, sir, in February 2014, the tribunals, appellate tribunals and other authorities, Conditions of Service Bill 2014, which is pending in this Honorable House. What does it say? It says that if you become a member of any tribunal, you will not undertake any arbitration. If you have any pending arbitration, you will complete it fully and you will not undertake any arbitration. That's the point number one. If you are a member of the tribunal, you shall not practice before tribunal and all these things. Therefore, even that concern, sir, with greatest of respect, has been addressed by this bill, which we are pending, which we will have occasion to examine in detail, sir. But, sir, there is a larger issue. And the larger issue is, it is our government's mission to make India a hub of international arbitration. I have also requested the Law Commission to kindly improve upon the existing Arbitration Act so that to make it more expeditious, sir. Now, Mr. Shantaram Naik was there. He was mentioning about alternative dispute redressal mechanism. If we have to reduce the load of the pending cases, Honorable Vice Chairman, sir, then we need to have alternative forum. And we need people judicially trained for that alternative adjudication. Arbitration is a part of that. We have got judges and we have got judges. We have got very eminent judges whose honesty, legal knowledge, judicial scholarship has been a matter of great standard for us. Therefore, sir, I would request Duaji to kindly consider, if you have a complete blanket ban that no retired judge ever can undertake any arbitration, that maybe wittingly or unwittingly you are impinging upon the success of alternative judicial redressal mechanisms. Because many times judges also encourage parties to go for compromise, to go for arbitration, to go for mediation, and at times retired judges of eminence are themselves chosen in the court itself by common consent. Now, if we have a complete bar, so that great window will be stopped, sir. Therefore, I note the concern of Duaji, but in the light of healthy growth of alternative mechanism for judicial redress, I think he will not insist upon that. But the other concerns have been addressed by the bill which I referred to and by the judgments of the Supreme Court I referred to. This is what I would like to say. Larger issue of judicial reform. Yes, National Judicial Commission is also a matter of priority for our government. It was also a matter of priority for your government because it is not a political issue, it is a national issue. And let me tell you, the mission of our government is very clear, Honorable Vice Chairman. We respect complete independence of judiciary. We all have the highest regard for also the office of Chief Justice and judges. But as far as the collegium system of appointment, the government has got the right to be consulted and the government has got the right to seek a reconsideration of the proposal made. Such a right is available to the government in the domain of Supreme Court judgment itself laying down the collegium system. The government only exercises that right of reconsideration based upon cogent ground, objective, fair ground, and based upon the past precedents. As far as the question of age is concerned, that is a debatable issue, sir. The government has not taken a call. There are views for it, there are views against it. People say, why only judiciary? Raise the age of all other constitutional functionary who are holding like commissions, like other things. We will have to, yes, we will have to take a call on that. But yes, those issues are there, sir. Sir, with this all, may I request Honorable Duaji that he has flagged an issue of great importance. On behalf of the government, I take note of those concerns. But the government is alive for that. Whenever judicial reform issue will be there, this will be addressed. One bill is there and the judgment has come. So with these, I would appeal to Honorable Duaji to kindly consider withdrawing his bill, sir. That's how I'll see.
Thank you very much. Mr. Dua, you have to reply.
Certainly, Mr. Vice Chairman. Nobody in this House wants to do anything which may even cut into independence of the judiciary by an iota. He wants India to be hub of arbitration, and I can well understand why this alternate settlement of disputes is being preferred all over the world, and why not in India, where courts are overloaded with the work. It will be speedier, possibly it should be cheaper also. I didn't know about the arbitration bill pending still. It slipped my mind, but I would like since the minister is going to review that bill, if he can provide some guidelines for the arbitration process, because this is outside the court. You can't lay down the laws for this, but you can regulate it. And if there are some guidelines which can meet all concerns, most concerns about arbitration process, I think that will be helpful when he reviews the bill which is already pending. The point which I was making is that the Supreme Court judges and the Chief Justices doing arbitration cases. There the problem still remains. I think that needs to be looked into when you examine the arbitration law. The question is the high fee which the arbitrators charge from the corporate sector and both the companies, a high fee which are paid. And sometimes the arbitration hearings are held abroad. Well, in the globalized world that can't be avoided, but just for sometimes for holiday purposes, the arbitration proceedings are held abroad. Some guidelines I thought should be provided when the law minister will examine. In view of his assurances, I won't press the bill for.
The bill is withdrawn.
कुल मिलाकर इस गैर सरकारी विधेयक पर हुई चर्चा काफ़ी बेहतरीन रही। इसमें सांसदों ने तमाम महत्वपूर्ण सुझाव दिया। साथ ही साथ सरकार ने भी खुले दिल से माना कि मुकदमों के बढ़ते हुए बोझ से सरकार चिंतित है और इससे निपटने के लिए तमाम इंतजाम किए जा रहे हैं। लोगों तक न्याय सस्ता और सुलभ हो, साथ ही साथ उच्चतम न्यायपालिका की गरिमा और उसकी मर्यादा की बहाली के लिए सभी संभव उपाय होंगे। सांसद एच के दुआ के विधेयक को वापस ले लिया गया, लेकिन इसके बावजूद मूल सवालों पर जिस तरह से गंभीर चर्चा हुई है वह राज्यसभा के इतिहास की एक बेहतरीन चर्चा के रूप में याद की जाएगी। इस एपिसोड में फ़िलहाल यहीं तक, आगे मिलेंगे किसी और खास एपिसोड के साथ, तब तक के लिए धन्यवाद।